Hello and welcome to this edition of the Housing Ombudsman Service podcast. I'm Victoria King, one of the Sector Learning and Development Leads here at the Housing Ombudsman Service. And today our podcast will be on the topic of Awaab's Law. Now, I've got the pleasure of being joined by two members of the dispute resolution function here at the Housing Ombudsman Service, John Hoary, who's currently Head of Dispute Resolution, acting up, and Stephen Parfitt, who you might be familiar with from some of our previous podcasts. And Stephen is a dispute resolution manager, also acting up here at the Housing Ombudsman Service. So before we kick off with some questions about Awaab's Law, John and Stephen, would you like to introduce yourselves? Maybe John, you go first.
Sure. Hello. I'm mindful that Stephen is famous on these podcasts. My name's John Hoary. I'm the acting head of dispute resolution. I've been at the Ombudsman now since 2017 and started off as an adjudicator. So Awaab's Law's come in, and Stephen and I have been doing lots of work on the guidance for Awaab's Law and what the Ombudsman's approach will be. So very happy to be here, Victoria.
Thank you, John. And Stephen.
Yes, I'm Stephen Parfitt. It's nice to be back. I've been at the Housing Ombudsman Service for just coming up on 3 years now. Also started as an adjudicator very recently as an acting up DRM. Yeah, really been a pleasure to work with John on the guidance and looking forward to discussing it all with you today.
Thank you both. So we're recording this here in January 2026, and Awaab's Law Phase 1 came in back at the end of October 2025. Now, there could be some people listening who are perhaps new to social housing, perhaps not sure of what Awaab's Law is. Could you just give us a brief overview of how we got here and where we are now with regards to the law?
Okay, so for us, it started with a damp and mould and the damp and mould cases that we see. It started with the tragic death of 2-year-old baby Awaab Ishaq in December 2020 in a social housing home. In 2022, the coroner ruled this was caused by constant mould exposure to black mould. So following a media and political campaign, the government vowed to introduce Awaab's Law. And so now we have an implied term into social housing tenancies that say that landlords must comply with prescribed requirements, and the government has laid those prescribed requirements in the Social Housing Regulation Act and the Social Housing Prescribed Requirements England Regulations 2025, and together these are known as Awaab's Law.
Okay, what triggers Awaab's Law?
So to trigger Awaab's Law, the landlord needs to receive or have knowledge or ought to have had knowledge of a potential emergency or significant hazard, and those have different definitions. But crucially, this notice must have happened on or after the 27th of October 2025, or where a hazard was reported before that date, and there has been, again, what's defined as a material change on or after that date, the landlord receives notification of that material change. Now, those are all specific legal concepts within the prescribed requirements, which all have sort of different definitions. But really, the headline is the landlord receives notice of a potential hazard that could be an emergency or significant on or after the 27th of October 2025. That starts the prescribed requirements, and the landlord must duly start its investigation.
That's right. And I think the other thing to add to that is that the notice doesn't have to necessarily come from just the tenant. It can come from the housing officer who might have been to the property and saw that there could be a hazard, or contractors sometimes. So it's really important that landlords take into account the wide range of ways that they can come into contact with notice in respect of Awaab's Law.
The notice could also come from us here at the Housing Ombudsman Service, so equally important to be aware if we send you a notice as a landlord that it could also trigger that Awaab's Law response required.
So how does Awaab's Law then link to wider repairs and maintenance?
So landlords have legal obligations to complete repairs. That's not anything new. That's been around for a very long time, and those obligations will be set out in the tenancy agreement, or they might be applied by legislation such as Section 11 of the Landlord Tenant Act 1985, for example. The landlord would also have its own repairs policies and procedures, which will set out its repairing obligations, which may be in addition to its baseline legislative obligations. So Awaab's law doesn't change any of that. Awaab's law doesn't change the obligations that a landlord has, but instead it prescribes certain actions and timeframes in which landlords must take those where there could be and is a potential emergency or significant hazard. So it's about really making clear to landlords through legislation the timescales that now apply. I mean, historically, a reasonable time frame was really the requirement for most repairing obligations, and this legislation sets out clearly for the hazards that are included within Awaab's law what that reasonable time frame is in terms of an actual number of days in which actions have to be taken.
I think the other thing to just note on that is that Section 11, which is a repairing obligation, well, you could only repair where something is in disrepair or it's not working properly. Awaab's law is much wider than that, because there could be a set of circumstances in the property, such as excessive cold, which might not result from a repair issue, but it would still place an obligation on a landlord to inspect and decide if it's an emergency or significant hazard, and then what steps it needs to take to make safe it if it is one of those hazards.
So how does Awaab's law link to the planned updates to the Decent Home Standard?
So as of early sort of 2026, the position on the decent homes has gone through a shift. We had the Decent Homes Standard, which was early 2006. So it's a long time ago, 20 years ago, I think it was. So now the government has vowed to update the Decent Home Standard. It went through a consultation for a little bit, and what the government has said it wants to focus on is this parity and that ensuring every tenant, regardless of whether their landlord is a council, a housing association, or a private landlord, has a legal right to a safe home. So there will be some overlap. So currently, in the current Decent Home Standard, if there is a Category 1 hazard, then it will fail to meet one of the requirements of the Decent Home Standard. Now, we haven't seen the published version of the new Decent Home Standard, and I think the government has said that they're going to do that in the coming weeks. So it's likely to have something in there about whether there are emergency or significant hazards and it not meeting a decent home standard, so to speak. So it's a really good area to watch, and it's developing. We also know that the government has said that it will introduce phase 2 of Awaab's law around about the similar time scale. So it's really, really important to see and watch how that unfolds.
Thanks, John. That's really useful. Why is a landlord's complaint process the second line of defence when it comes to Awaab's law?
So landlords need to act when they're told or become aware of a potential Awaab's law hazard, but that notification may come through a complaint made by the resident. So the second line of defence being that the resident making the complaint may not be the first time the residents raised the issue, but that can and would trigger Awaab's law prescribed requirements if it's the first time the landlord is becoming aware of the potential, either as a notice on or after the 22nd of October last year, or as a potential material change if the landlord's aware of it before that date, and then the complaint is made after that date. So the point really is that it's another opportunity for the landlord to be notified and then to take action, follow the prescribed requirements to investigate that potential Awaab's law hazard. It must also do that as well as investigating the complaint through its complaints process, and both must run parallel rather than one after the other. because obviously the landlord's complaints process will have different time frames for responses, which will invariably be longer than its responses required under the prescribed requirements.
Just to add to that as well, I think the regulations say that if the notice comes on the 27th or after 27th of October 2025, it's regardless of whether the landlord already has notice of that. So a resident might have told a landlord about something on the 20th of October and then reports it again on the 27th of October 2025. The point being there, and I think Stephen, you and I have discussed this, is interestingly, if the landlord's already inspected and thinks actually this is a sort of minimal risk, the chances are it can use that information and say, well, actually, we don't think Awaab's law applies here. The reason being is because the obligation on a landlord to investigate doesn't necessarily mean that they have to physically inspect the property. And Awaab's law is quite clear that a remote investigation might be enough. So it's taken into account the information that it already has on that property as well.
So we've started to touch on this already there, but a landlord, they might have a case with them that was pre 27th of October 2025 when phase one of Awaab's law came in. Therefore, at that time, that particular case wasn't covered by Awaab's law. Can you tell us more about that material change? What does that mean in practice?
So material change is any change either to the hazard or to the health and circumstances of the residents or occupants of the property. So if that has materially changed since the first report to the resident, and that material change, the landlord has notice of it on or after the 27th of October 2025, the landlord must then reassess and decide if Awaab's law applies. Now, in practice, this can be something like the damp and mold in my home has got much, much worse, or the occupants in the property, such as my children, are now starting to cough and it's causing chest infections. So any of those reports, in our view, is likely and should cause a landlord to consider whether a material change notice has been given to it.
So I'm going to move on now to talking about communication. And whatever the sector, poor communication can drive complaints. And we've talked about it in lots of our publications here from the Housing Ombudsman Service. And in one of them, we talk about the 4 key ingredients of good communication, which is timely communication, transparent communication, tailored communication, and also having that communication at the right tone. So the 4 T's. Why is communication such an important part of Awaab's law and Awaab's law cases?
So good communication, as you said, is important when it comes to all aspects of the landlord and tenant relationship, landlord-resident relationship, because it helps resolve issues sooner. It avoids complaints and it maintains that good relationship between the landlord and the tenant or the resident. Within the prescribed requirements set out under the regulations for Awaab's law, it says that landlords must keep residents updated about the outcomes of investigations, about any works, repairs required, and about the sort of progress with those repairs. There's also requirements to provide a written summary to a resident within 3 working days following an emergency or standard investigation. So really, throughout the prescribed requirements, there is a strong emphasis on good, clear, and timely communication between the landlord and the resident, so that the resident understands what's going on, whether there is a hazard that is an emergency or significant present, and what the landlord is going to do to resolve it for them. And the whole basis really is that if the resident knows what's going on, that can really help maintain that landlord-tenant relationship and help to get those issues resolved, as quickly and as properly as possible for the resident. So in all complaints, good communication, in all instances of tenants and landlords relationships, with good communication, but with a particular emphasis on the hazards within Awaab's law. That need for good communication is absolutely crucial.
And I think the other thing it does as well is it alleviates worry and concern by the resident. I think this is an important point for me, that if I reported damp and mold and it was quite bad and I don't know where it's coming from, I would want to know that my landlord knows and understands that I've reported and what the next steps are going to be. So actually, that will alleviate a lot of concerns and worries from residents where they're left sometimes without information. That can be a deep source of distress and inconvenience, I think, and certainly in the casework that we see, and we can see that a lot in the cases that we see.
Thanks both. How can good knowledge and information management, or record keeping as it's known sometimes, support landlords?
Well, it helps landlords to demonstrate that they have done what they should have done. I think that's first and foremost. So it is key for a corporation to be able to demonstrate, hey, you know what? I have done what I should have done, and I know that I have because here is a piece of information or a record and a piece of evidence that was created at that time, which demonstrates that I did what I should have done. So it's that thing. So it's reassurance for the landlord. Now, if the landlord is doing this and is able to show and that it's done what it needed to, then that's great. And that's the types of things that we want to see. And we think that's really good practice. A lot of the time, things move quickly. So landlords and contractors might not make as in detail notes as they perhaps should, but it's one to really take stock on and for landlords to train their staff on. They're actually taking really good notes and jotting down and writing down the information at the time is going to be really important to demonstrate that you did what you should have done, not just to the ombudsman, but to regulators and anybody that might ask questions about what happened in a particular case.
I think also to add, and certainly from I've got frontline experience of managing social housing properties, and the benefit to everyone involved and having really good knowledge of your properties and your residents, being able to know the type of properties that you have within your stock, where they may be potential for hazards to arise, having really good information about which properties might be affected by damp and mold, for example, and also having really good knowledge and records about the residents that live in the properties, any sort of disabilities or vulnerabilities. That can help in two ways. Firstly, it can help resolve issues before they become hazards by being able to take proactive actions or maintenance. It can also help the landlord to determine whether Awaab's law is applicable, whether there may be an emergency or significant hazard, because the landlord will have that knowledge, particularly about the residents within the property, and be able to make good and well-informed and well-evidenced decisions around that. So the more a landlord can know about its properties and its residents, on a unit by unit, on a house by house basis, is only going to benefit everyone involved.
We talk about that a lot in our Spotlight reports, and the Spotlight report on knowledge and information management is available on our website. So is the Spotlight report on attitudes, respect and rights, which covers some of those things you discussed there in more detail. So if you're listening to this, please do check them out if you haven't read them already. So back to Awaab's law then. Consistency and discretion are key in Awaab's law. Can you tell us more about why this is?
I think at first glance, you may say they are at polar opposite ends as sort of conflicting concepts of how to be consistent and also exercise discretion. Surely they're the opposite thing. I think the important thing really, and again, this goes for everything a landlord does, not just for Awaab's law. Landlords need to apply their policies consistently and fairly across the board when they're making decisions and taking actions. And that's certainly something we look at when we investigate cases here at the Ombudsman Service. But also, there needs to be that ability and built in to have some discretion and to be able to make some different decisions or slightly depart from a policy if appropriate and based on good reasoning and evidence. And the most obvious example here would be reasonable adjustments for resident vulnerabilities, perhaps the prioritisation of repairs or undertaking repairs that landlord wouldn't ordinarily do, but for it to assist resident with vulnerability as reasonable adjustment. Really, I think it's about having good, clear decision making. And this really goes back to the knowledge information management point as well. Being able to evidence the decisions you've made, being able to use the knowledge and information you have, and being able to clearly document why you've made certain decisions, especially where you have departed from your policy, so that anyone sort of later on looking at it can say, well, yes, the policy said this, they did that, but they did it because of this reason, and they based that reason on that evidence, and therefore we can see that that was fair and reasonable in the circumstances of that particular matter.
It's funny because lawyers grapple with this a lot, don't they? Being consistent, which means following a set standard of rules or policies strictly, but also having discretion in that. So the way that I often say it is to do that and be able to do that, your policies and procedures are there to ensure, for most respects, everyone's treated fairly. So you're looking at around about 80 to 90% of box standard cases being applying the regular policy, which should be applied in a common sense way. Then it's those exceptions to the rule where the policy might not quite fit. So it's making sure that you're not being so rigid that you don't take into account something that's sort of new and is unique and has lots of different moving parts to it. That you're not trying to put those through a very strict policy. So that's the area that we really want landlords to focus on. That actually, is this an exceptional case and should it be treated differently? And if it should be treated differently, that's okay. We just need to know why you've treated it differently, or why you've not applied the policy in that case, or why you still felt the policy applied. So it goes back to Stephen's point on knowledge, information and management. Document those reasons. I've made this decision because, and it can just be bullet points. And at some later point, somebody will be able to look back at that and audit it and go, actually, we can see that a decision was made here and for the right reasons.
Thanks, both. So we talked earlier about the landlord's complaint process being the second line of defence. Then, in theory, then the Housing Ombudsman Service is the third line defence. So if the landlord's complaint process is the second line of defence, then we're the third line. What is our role here at the Housing Ombudsman Service in relation to the law?
So I think in terms of our investigations, it's always open to us to look at what the landlord has done and to look at whether the landlord has drawn its mind to the right questions at the time. So that's why we're a third line of defence for landlords. We can give it that learning so that it can change its processes and update its processes, really, is what we're saying. But we can notify landlords for any part of our process that there might be an emergency or significant hazard, and we let landlords know about that as quickly as we possibly can, where we're given that notice. We can also advise residents what to do in terms of complaint handling. But really, our third line of defence for us is looking at what has happened and really giving that landlord detailed feedback, essentially, on if anything has gone wrong and what might have been the causes or triggers for that, to help it change its processes and policies where it needs to.
So here at the Housing Ombudsman Service, and you talked about this earlier on, John, we produce some guidance. How does the guidance that we produce differ to the guidance published by the Ministry of Housing, Communities and Local Government?
So I'll hand over to Stephen on it, but I'll just make one point on this. I think for us, our guidance is about how we will apply Awaab's law in our casework. Now, of course, Awaab's law is the law, and one of the things that we look at when we're investigating is whether the landlord has complied with any relevant legal rule. So we will look at that. What we often don't do is make final binding judgments in the same way as a court might. So I think Awaab's law and the ministry's guidance is generally how landlords should apply the rules. And our guidance is when it comes to us, what are the types of things that we'll look at and how will we try to answer those as part of our investigatory process?
Yeah, absolutely. I've not really got too much to add. Sort of really well sort of summed up there. Sort of in working on this guidance and sort of really considering the government guidance as well. The, the guidance is broadly similar. And as John said, really sort of the emphasis within our guidance is an indication of how we will investigate complaints about Arab's law and the sort of considerations we will look at. But it also has some helpful information for landlords. We strongly advise landlords to read through in how they handle Al's law uh, cases that will give them some sort of hints and tips on what we'd be looking for, what we'd be expecting them to do to be able to show they are complying with Arab's law and our expectations around that. So absolutely, as John said, the government guidance and any sort of legal guidance that goes out is the sort of legal interpretation of it, and our guidance is in practice. This is what we think that means, and what you should be doing to show that you are complying with your legal obligations.
And I think as any ombudsman up and down the country, there's lots of them now in England, Scotland, and Wales and Northern Ireland. But as any ombudsman, we're always looking to strive for the sector to be and do better. So sometimes we might see Awaab's law as a minimum, but we can ask landlords or expect landlords to strive for higher standards, and that's the very nature of an ombudsman, really, that we can do. And I think the last point that we've tried to do in the guidance is be quite clear and prescriptive about when we think Awaab's law applies. So it really takes the information from the regulations and sets it out as a key checklist to help our caseworkers and anybody who might be looking at that to decide if this could be an Awaab's law case.
When a complaint does come to us to investigate, how do we decide if it's Awaab's law or not?
Oh, great question. There's a number of criteria that apply. So Awaab's law creates a focus on social housing right now, first and foremost. So part of that key criteria is ensuring that you recognise that this has to be a social housing tenancy. Now, that means it has to be below market rent and the property was made available for people who can't access the private rented sector. It also means that the landlord has to be a provider of social housing. So that would usually mean registered with the regulator. The property needs to be a dwelling in England, and we've just got to be mindful that there needs to be a hazard and it affects the dwelling, and that hazard can arise from something in the property itself or in the building or on land that's within the vicinity of the property. So if you follow those through as a sort of guide and checklist and ask yourself, well, do I have a social housing tenancy for a dwelling in England? Tick, I go on to the next question. And if you follow our guidance in that way, it should help you to arrive at the right outcome as to whether Awaab's law applies or not. The key sort of criteria, if you like, is has there been a report on or after the 27th of October 2025 of something that could be potentially an emergency hazard or a significant hazard? And in the guidance, we try to break that down about what those definitions are and look like, which I won't go into detail here, but hopefully that gives you a flavour of some of the key criteria that we would apply and we would look at to see whether Awaab's law applies.
And then to take that one step further, we'd then be looking, well, did the landlord consider this criteria? Did the landlord make decisions based upon whether Al's law could apply or not based on the facts of the case in front of it? And did it evidence its decisions and document its decisions, whether it decided Al's law didn't apply, or if it decided Al's law did apply, did it then follow the prescribed requirements? And again, evidence what it did and why it did it. So again, it goes back to knowledge information management as well.
Yeah, the importance of having those records. Is our guidance available to external people to look at? Is it on our website?
It absolutely is on our website. I was just looking at it yesterday and going through it. So it is there. It's got little drop down boxes there to help you and give you our sort of quick tips and hints on how the ombudsman will look at it. So yes, it's all there on our website for everybody to see.
Amazing. What do we do if we at the Housing Ombudsman Service get a complaint from a resident, which is Awaab's law, but they haven't exhausted the landlord's internal complaint procedure?
So this is a big one, and I think it's a big one that we want landlords to really know and understand. Awaab's law and the complaint procedure are two separate matters that the landlord has to consider. So notice of a material change or of one of the hazards under Awaab's law is for the landlord to act upon and to act upon immediately. So whether that comes to the landlord by way of a complaint, it needs to act upon that notice of a potential emergency or significant hazard or material change. That's for the landlord to do, and it must do that regardless of how it receives notice. For our purposes at the Housing Ombudsman, our rules say that we can't investigate a complaint until the landlord has had an opportunity to respond to the complaint via its internal complaint procedure. So the complaint procedure itself is an opportunity for a landlord to put it right. What we don't want to see landlords do is receive reports about a potential emergency or significant hazard and put it into the complaint procedure and then allow the timescales in the complaint handling code to apply. Because if they receive a notice of a potential emergency or potential significant hazard, then to deal with those specific issues, the timescales in Awaab's law applies. So it's really important that the landlord recognises that. And you can have two procedures going on at the same time. So you can have the inspection and make safe works going on whilst the landlord is still considering and preparing a response to the complaint. So it's really important that the landlords treat notice under Awaab's law and a complaint separately.
Can you tell us a bit more about how we're going to be investigating Awaab's law complaints when they come to us?
So the basis for an investigation of any complaint that we receive once it's completed the landlord's internal complaints process is to look at whether the landlord met its legal obligations and whether it followed its policies and procedures and acted in a way that was fair and reasonable in all the circumstances. So that's sort of the basis really of how we investigate any complaint here. So in relation to Awaab's law, we would be looking at the landlord's decision making around whether it recognised or how it determined whether Awaab's law did or did not apply, and whether its reasoning for that was based in evidence and well documented. We'd be looking at whether the landlord followed the prescribed requirements if it decided that Awaab's law may apply, and again the decisions and actions it took at each step with each of the prescribed requirements, whether it followed its legal obligations, whether it had created or amended any of its internal policies to cater for Awaab's law cases, and again whether it acted fairly and reasonably in the circumstances. So that all goes back to the earlier question about consistency and discretion. We expect landlords to apply their policies and procedures consistently, but also allow for that discretion in appropriate circumstances. And as I said earlier, that there's sort of information and sort of reasoning of how we will investigate Awaab's law complaints within the guidance that we produce that, as John said, is available on our website, sort of for the more intricate advice about particular parts of Awaab's law that it would take far too long to go through on a podcast.
I think it's important that to remember that actually we're reviewing something and what the landlord has done. So we'll be asking whether if the landlord has drawn its mind to the right questions in Awaab's law, and that's what our guidance should help landlords to do when they know a case is coming to us. And so we'll be asking those questions. I think the other point, which is slightly nuanced, is that even if Awaab's law doesn't apply sometimes, it's also thinking about, well, what other provisions apply? Because actually the landlord might well have fairly assessed it and decided that Awaab's law doesn't apply. But then there are other questions that we would ask ourselves then if Awaab's law doesn't apply. So that's not just the end of our investigation. We'd also look at, well, was there a repair obligation? And we'll also think about whether the property was fit for human habitation and whether the landlord fairly considered that as well.
Bit of a hypothetical question, and it sort of leads on from what you were talking about there. What happens if a landlord hasn't identified Awaab's law correctly? What will happen in that circumstance?
What we'll do is we'll set out why we believe there was a notice to the landlord of a potential significant or emergency hazard or a material change. And we'll say what the landlord ought to have done in that circumstance. We'll then look at what the landlord did do. And if it hasn't correctly identified it, that is a great opportunity for learning. And we'll explain to the landlord what it could have done differently in order to have recognised that this was potentially an Awaab's law case at the earliest possible opportunity. We also might say that the landlord failed in some material respect. So we might be making orders and recommendations that a landlord needs to do something to put the resident back into the position they would have been in had it have correctly identified that Awaab's law applied. Now, one of these might be an order that the landlord investigates within 24 hours in line with an emergency hazard, where we think that there is an emergency hazard or is likely to be an emergency hazard. So it's just those ones really. So there are two parts to it. Looking at the personal circumstances of the resident and how can things be put right for them if the landlord hasn't got things quite right. And then secondly, what is the learning for that specific landlord? And then, as you know, Victoria, every so often we publish insight reports and learning from severe mal reports, and then we'll publish what we're seeing to the wider sector so that everybody can learn from what we're seeing.
I think that's a really good point as well, to emphasise that John made there about the potential orders we may make, and if our law is in play, that we may depart from our usual timeframes around orders, which could be around sort of 4 weeks to comply, and may have to order an order that has a much shorter time frame, such as 24 hours. Or within a number of working days as opposed to a long period. So just something really to be aware of. I think if you know, as a landlord, you've got a case with the Ombudsman Service for Investigation that has Awaab's law potential, that you may get a short notice order is a possibility.
Just for those listening, you've just spoken there about orders and recommendations. So orders the landlord have to do, and recommendations we suggest they do. Is that correct?
That's absolutely right. So our scheme rules say that landlords are bound by the terms of the scheme, and the second part of the scheme talks about landlords having to provide evidence of compliance with our orders. So that's absolutely right. Our orders are binding on landlords.
Well, thanks for clarifying. Can you tell us more about suitable alternative accommodation in cases where Awaab's law applies?
So, under the prescribed requirements, one of the prescribed requirements is for the landlord to consider and provide suitable alternative accommodation. This would be if there is an emergency or significant hazard present. So, once the landlord has carried out an investigation and established that there is that type of hazard present, and it must offer alternative suitable accommodation if it cannot make the property safe within 24 hours for an emergency hazard or within 5 working days for a significant hazard. It must provide that alternative accommodation until the works are completed or there is no longer a hazard, or until the resident, if the resident so wishes, tells the landlord in writing that they no longer require that accommodation. The offer must be suitable. That's to say, it can't be any offer of any alternative accommodation, but the landlord must take into account the resident's needs and vulnerabilities, if any, and any other circumstances that may be relevant in making that offer of suitable accommodation. So really, it's the whole point is the landlord's identified there is this emergency or significant hazard. It can't make it safe within the timeframes stated. Therefore, it must offer this suitable accommodation, alternative accommodation, to take the resident's household out of that hazard. It's then under a duty to make safe and carry out the works to repair that hazard as soon as it practically can. But for the meantime, at least the resident's out of harm's way, if you like, in suitable alternative accommodation.
Just a point on that, the regulations say suitable alternative accommodation. It doesn't say like for like accommodation. So you've just got to bear in mind that sometimes there might be a difference in view between what the resident sees as suitable alternative accommodation and what the landlord sees as suitable alternative accommodation. My advice to landlords is if the resident explains to you why it's not suitable, you need to make a decision. You need to take that into account and explain whether you agree with them, uh, if that's the case, or if you don't agree with them, explain to them that's the offer and why you consider it suitable. That then makes things very, very clear that the landlord has set out why it believes that accommodation is suitable. This is an area that can potentially drag on with communications back and forth. So it's about setting out the decision right away at the earliest possible opportunity, even if that's a decision that the resident might not want to hear. It also allows the resident at that point to raise a complaint and dispute that. I think the other thing that we need to just be mindful of is that what Awaab's law doesn't do is take away a landlord's obligations in other areas. So lots of landlords have decant policies as well. So if the decant policies give residents more favourable options than what Awaab's law does, then the Ombudsman will also look at what a landlord's policies and procedures say as well and say, well, actually, yes, suitable alternative accommodation was the minima, if you like, but actually your policy said that you would provide a like for like accommodation in that scenario. So we're also looking at whether a landlord complied with its own policies and procedures as well. And even if there is an emergency or significant hazard, some of the landlord's own policies and procedures and decant policies specifically will also set out when they will offer alternative accommodation. So it's just making sure that landlords apply that correctly, even if there isn't an emergency or significant hazard.
We've touched on our orders and recommendations, but what orders and recommendations would we potentially make in a case that we've investigated where we find service failure or maladministration or severe maladministration, for example? What remedies and redress are appropriate?
So one of the things that run through the decisions that we make in terms of outcomes is our dispute resolution principles. So the first one is be fair, the second one is put things right, and then the last one is learn from outcomes. So our orders will broadly relate to those three areas. So being fair and putting things right, again, I previously mentioned, it's about putting the resident back into the position they would have been in had the failure not occurred. Now, in some respects, that's difficult because we can never give you back time and take away the frustration you experienced trying to get the boiler fixed or having to email. That's something that we just have to recognize. In that scenario, we often make a payment of distress and inconvenience or compensation for distress and inconvenience to recognize that the resident experienced some level of upset by what had happened. And that's what it's there to do, is to recognize that there was time spent, there was upset caused, there was frustration. And those compensation payments can range from something smaller, like 50, £100, right the way up to, as we've seen some decisions in current times, £2,000 possibly, depending on the distress and inconvenience caused. We do have current guidance online that's on our website currently that will tell you how we work out those ranges of award. We're also updating that guidance, and the sector can hope to hear something from us very soon. Watch this space on what our approach to compensation will be. So that's the first area that we can do, which is compensation to recognise distress and inconvenience. And the ranges can be wide depending on the distress and inconvenience caused. The other area is an order to inspect. Now, the landlord might have already inspected, but we think actually the inspection needs to be done again and something else needs to be looked for. So we can order inspections and we can be quite detailed about what we're asking the landlord to inspect for. The other area is do the works. Our scheme rules are very clear that we can tell the landlord to do works or not to do works, as the case may be. So this is one of our biggest areas in cases of repairs, and it's likely to be a big area in Awaab's law cases where we tell the landlord that it must do something, and it must do that within a specific period of time. And then we have our learning orders. and wider orders, what we might call them. So our learning orders is for the landlord to go away and think about why things went wrong and what learning it can take. Now, our wider orders allow us to order a landlord to review a policy or a practice that happens within the organisation, and then to report back and do a real root cause analysis. So those are just some of the orders that I can think of off the top of my head. Stephen, I don't know if you could think of any more.
I think the other one that's really worth mentioning is where we find a failing, we will almost always order a landlord to apologise to the resident. And we do that for two reasons. One, it's for the landlord to be able to recognise the failings that we've identified and to be able to take on board those failings, to apologise for those failings, and to be able to say or demonstrate how it has learned or will learn from those failings. And also, it's about the resident feeling recognised and understood. We hear quite often through complaints that residents feel like the landlord hasn't listened to them, hasn't understood what they're trying to say, hasn't fully appreciated the effect that the failings or the situation has had on them. And so the apology order is again another opportunity for the landlord to be able to acknowledge something went wrong and that it had the effect on the resident, and the resident can get that kind of closure, if you like, that finally their grievance has been listened to, they've been understood, it's been recognised, and the landlord is now promising to put things right and to learn from that outcome and to do things better in future. So I think it's a really important part of what we do here. Very different to say the courts process where it's all about the compensation or the monetary order. Here it's about that recognition as well of the effect it has had and how things can be made better and hopefully restore that landlord-tenant relationship as well in the process.
Such a good point, because an apology is about accountability and accepting responsibility, isn't it? So yeah, I should have picked that one up.
You touched on learning from complaints and the importance of that. How can landlords use the learning from Awaab's law complaint cases to learn to stop the same issues from being repeated in the future?
Yeah, really good question. So, I mean, so much of this goes back to sort of what we've been discussing today about having good knowledge and information management, about having good policies and procedures, and sort of being on top of your properties and your residents. And so I think really learning from Al's law complaints really points towards sort of proactive repairs and maintenance. It points towards understanding the nature of your properties, understanding the makeup of your residents, vulnerabilities, disabilities, and anything else that could really help you to understand the likely hazards that may occur in the properties and the likely effects they may have on your residents. So when you look at the learning from cases, whether that's cases decided or a complaint of your own, really take on board, well, where were the points along the process where the issue could have been stopped or the problem could have been resolved? Was it initially knowing that that type of stock is perhaps more prone to damp and mold than other stock, and therefore we could have carried out more regular surveys or more regular sort of works? Or was it at the point where we found out that actually the resident had disabilities and therefore the effect of that particular hazard was having a much greater impact on them than on another resident? So really it's sort of looking at those points where having good knowledge information and therefore having the ability to react, or even better, be proactive to sort of stop those hazards occurring before they even start, is better for everyone, because it's better for the landlord in the long run, it's better for the resident, it maintains the relationship, and also it can avoid the need for complaints and sort of further work later down the line as well. It's always easier to resolve something before it happens than to chase after it once it's running down the hill, trying to stop it at a later point.
And it's that cycle, isn't it? It's that cycle of improvement. As part of a cycle of improvement, you've always got to have that moment of taking stock, learning and reflecting to be able to move forward. I think it's happens in lots of other sectors as well. But I think if you think of yourself as an athlete, really, a gymnast, for example, your coach will tell you the bits that you can improve on because they're stood outside and they're watching from the sidelines. So it's really, really important that actually when we publish those reports, really take a moment to take stock. Really ask yourself, what does that mean for this organization? Because that's the thing that will help you improve and move forward, I think, and be that top athlete.
That's a really good point as well, because quite often we see in complaints, you'll have the repairs team and they will be doing their thing, and then you'll have the local housing officer who will be doing their thing, and then you'll have the complaints team who will be doing their thing. But the ability to have that sort of holistic view, that sort of top-down view of everything, to join up all the dots and equally to see where things perhaps are being missed or where things are being duplicated, to sort of make your own processes and procedures more efficient as well, and therefore more timely. So yeah, absolutely what John said about, consider the learning as a whole organisation rather than just as a sort of department by department, and see where the improvements can be made across the whole landlord as a business.
So we're in early 2026 now. Phase two of Awaab's law is going to be coming in October 2026. What will be included in phase two?
So we know that currently all the hazards in the housing health and safety rating system apply to emergency hazards, except for crowding and spacing. And phase two really only relates, from what I understand, to significant hazards, which at the moment only applies to damp and mold. So it's really how the government open that up to say which other of the hazards in the HHSRS will come to apply. Um, and we will find that out shortly. Again, we've heard that from the government that they're going to be talking in the next few weeks about what that's going to look like and what phase two is going to look like. So it's a really interesting point about phase two, and will any changes be made to what's already happened in phase one of Awaab's law? That's very unlikely, but we can only see. But it's about opening up the number of hazards that apply to significant hazards at the moment, which only apply to damp and mold right now.
So we're nearing the end of this podcast. So I'm going to ask you, you've both been working for a while now on Awaab's law here at the Housing Ombudsman Service. What would be your main reflections on what you've seen so far? And do you have any key messages that you would give to landlords?
Oh, I think for me, I think it's know your definitions in our ABS law. So I think if we look at an emergency hazard, we know that there is a hazard, so one or more of the hazards in the HHSRS that is cause significant and imminent harm to the occupants of the property, such that a reasonable landlord with relevant knowledge would want to take steps to make safe within 24 hours. It's just knowing those things and making sure that the correct teams know what that means. So those people who are answering the phone lines to on the repairs lines, for example, making sure that they know and understand what that significant and imminent harm means. It means something bad could happen quite quickly if we don't act on this now. Knowing what relevant knowledge is. So what do we know about the resident and their household? What do we know about the hazard? What do we know about the property? And based on that, should we get something done within the next 24 hours? So it's just really being on the pulse of that and making sure that those ones don't fall through the nets, I think for me is a key. And thinking about what that means for out of hours services. Landlords will get out of hours reports, and I think traditionally they said this one isn't an emergency, ring back on Monday, for example. Well, technically they've had notice, so actually, it's for the landlord to get right as soon as possible. So just making sure that you know and understand those definitions, and making sure your front end staff know those definitions, is going to be key to its success, I think, from my perspective.
Yeah, really, really good point. Al's law creates obligations, and obligations with strict timeframes, and those obligations are universal across the board. So where landlords are used to working with what's our repairs policy, what's our emergency repairs timeframe, for example, that's almost now what it has been for potential emergency or significant hazard, superseded by Awaab's law requirements. So it's, as John said, so every member of staff, everyone in the organisation, really knowing what those requirements are and what those possible triggers are, and therefore being able to react in the correct time frame. And it goes back to what I've said, and we'll keep saying: know your properties, know your residents, and that will make your life so much easier.
And make notes and update. So you will be surprised how important some of those notes and that information will be.
That brings us to the end of the podcast. Thank you so much for your time today, Stephen and John, and thank you to those who've listened to this podcast. We've talked about our guidance, we've talked about our spotlight reports. They're all on our website. We'll keep continuing to share the learning from complaints and the complaints involving Awaab's law via our Centre for Learning, and we will be producing more resources for you over the coming months. You can keep up to date with new items on our website, which is www.housing-ombudsman.org.uk. And if you're a member landlord of the Housing Ombudsman Scheme, you can access learning resources for free via our Centre for Learning Landlord Hub, details of which you can also find on our website. Thank you, Stephen and John, and thank you to everybody that's listened.
Thanks for having us.
Thank you.